I am there. I am there.
Yes, sir, I
Abraham.
can hear you.
Okay, good. I wanted to be sure that you could hear me because that's the essence of this whole thing, right?
Yes, sir.
That is what. Um, I don't know. So I think if I join in with my phone, if my phone rings, it will cut off, right?
Yes, sir.
So I should try to log in with. I don't know why I find it difficult to log in through. Why is it not logging in through my? Okay, so iPhone are connected. Where do I get a Wi-Fi from now? Bluetooth not connected. Something going on. Uh, okay, I think this will work.
Oh,
Okay. Nah, chicken meeting. I don't see anybody.
Milord,
Ah,
good afternoon, sir.
good afternoon, my lord.
How are you?
Yeah.
Fine, thank you, sir. Good afternoon, Sir Falabi.
We actually have to say that good evening, afternoon, my brother. How are you?
I'm good. So we'll start
Fantastic. So,
exactly 3 p.m.
yes, fantastic. So we just keep to time. Yes.
Exactly. Okay, I think the room has been open for participants to start coming in.
Okay.
Interestingly, we have over 10,000 people registered. So let's see how we
Yes,
go.
I noticed it's quite a over 9,000 registered.
10,000.
Yes, sir.
Wow.
Yeah.
And I can see that right now, even at 3 o'clock, you have about 100 join. Okay.
Yeah, it's 224. So let's see.
Oh, 220. It keeps growing. 230 persons have joined. 233. Wow. My lord.
Yeah, so
Hello?
My lord, we're here.
yeah,
I can't even see myself.
yeah,
I don't know
we'll
that the
start with
video is
a
working.
Okay, my lord, I think it's your device.
hit
My
up,
lord, we
my
need to
lord.
look at the video. I think my
Okay,
lord
we
will
can
need
see my
to.
lord now.
Yeah.
Yeah. And when he starts speaking, the full screen will project him, so it'll be easier.
Okay, fantastic. Okay, good.
Yeah. Good afternoon to everyone, especially my Lord Justice Bibi Kanyip, who is our facilitator for today. and my good friend and brother, Mr. Falabi Kuti. My name is Tobena Erojikwe. I am the chairman of the board of the Practical Training Academy, an accredited academy of the Nigerian Institute of Continuing Legal Education. I'm delighted to welcome you all to today's training session. Significantly, this is the first training session of the Practical Training Academy, and we are starting it with a series on employment law. And who better to kick off this series than the president of the National Industrial Court himself, whom you will all attest to has been very generous to us over the years at the MBICLE, sharing his knowledge and insights and great wisdom on employment law with us. Today's moderator is Mr. Falabi Kuti, Senior Advocate of Nigeria. My role primarily is to do the basic introduction, and I would allow Mr. Kuti the discretion to run the training as he sees fit, and especially to do the honors of introducing formally and properly the facilitator for today. Thank you very much, everyone, for joining, and I hope we all have an eventful session. God bless you all.
Thank you very much, Tobina. Good afternoon, everyone. I would take it off from where my brother and friend Tobina Erujikwe left it off. This is nothing but a continuation of all the great work Tobina was known for when he headed the MBA ICLE. And it is thus no surprise that he has the Practical Trade Legal Academy to continue with interactions that is geared at ensuring that continuing legal education is part and parcel of what we do as lawyers. And just like he said, we are starting today with the very first of this series. My Lord, the President of the National Industrial Court, we are grateful that at every point in time, my Lord, Honorable Justice B.B. Kanye, PhD, is available to share, readily available to share his great thoughts, knowledge, insights, perspective on employment, labor, industrial relations matter, especially as they relate to today's world of work. And just like Tobina has rightly said, we are starting with the first in a 4-day series, continuing legal education around the employment law. And my Lord is we're starting with my Lord today. It's not taking a particular format of my Lord coming here to present a paper. I recall calling on my Lord earlier yesterday to mention that, yesterday to remind of today's session. And my Lord was quick to say that there's no paper. My Lord is not coming to present any paper, but it's very ready to discuss all the issues. So it is more like an open check that enables all the participants to ask questions. So the ground rule around that is that the chat box is open. Please feel free to send in questions, comments, and I will be looking at those. My Lord is here to, we're interrogating a whole lot of topics around labor employment law. The objective is to have a robust discussion around those salient issues arising in employment and labor law, drawing from practical examples, and as practitioners or stakeholders, also what are the things that we need to know about the working of the National Industrial Court. So without much ado, I would go ahead to introduce my Lord. My Lord, the Honorable Justice B.B. Kanye is the President of the National Industrial Court. I cannot possibly go ahead to look into my Lord's profile without taking almost like an hour of the 2-hour session that we have. So what I'll do is that I'll just abridge and jump right in to say that my Lord has a rich pedigree from academy. My Lord taught at the Ahmadu Bello University. He taught law of contract, law of thought, commercial law, and law of taxation. Contract, thought, commercial law, and taxation. And no doubt at different times, this rich blend gets to come to surface in many of the illuminating decisions my Lord churned out from the bench. In 1995, my Lord was appointed the Senior Research Fellow by the Nigerian Institute of Advanced Legal Studies. My Lord took up this appointment and rose to the rank of Associate Research Professor of Law in 2000. While at the Nigerian Institute of Advanced Legal Studies, my Lord's research areas interest straddled the areas of consumer protection, law of taxation, commercial law, and labor law. And my Lord was also the head continuing legal education and consultancy 1996 to 2000, acting special assistant to the Director General and visiting lecturer at Benue State University, Makurdi, where my Lord taught subjects including law of thought, law of taxation, and consumer protection. My Lord was appointed a member of the National Industrial Court of Nigeria from June 2000 to 2006 by the President, Commander-in-Chief of the Armed Forces of the Federal Republic of Nigeria. In virtue of Section 27 of the National Industrial Court Act 2006, my Lord became a judge of the NIC. This position my Lord held from 2006 to 2008. From 2008 to October 2019, my Lord was a presiding judge and later administrative judge of the Lagos Division of the Court. And from 2nd October 2019 to 12th December 2019, my Lord was the acting president of the court. And on 13 December 2019, my Lord was sworn in as the substantive president of the court. My Lord has adjudicated countless labor and employment law cases and delivered seminal rulings and judgment. My Lord served as a member of the committee set up to draft the now defunct National Industrial Court Rules 2007. And interestingly, my Lord served as the chairman of the committee that drafted the current National Industrial Court Rules. That's the substantive rules of practice and procedure in the court. And we're glad to have my Lord being chairman of that. One or two questions agitating the minds dovetail around the use of the rules in court, and we'll come to that shortly. My Lord participated in the processes and discussions that led to the promulgation of the National Industrial Code Act 2006, as well as the third alteration to the 1999 Constitution, thus bringing in the 2011 the National Industrial Code fully within the structure of the Nigerian judiciary and the Nigerian Constitution. And my Lord, in 2015, participated in the adjudication of election disputes arising from the 2015 general election in Nigeria. My Lord was first the chairman of the National and State Assembly Election Tribunal for Osun State, and then later a member of the panel 2 of the National and State Assembly Election Tribunal for Rivers State. My Lord is a holder of an LLB Honor Second Class Upper Division 1985, awarded by the Ahmadu Bello University, Zaria, and was also awarded at the Nigerian Law School in 1986 with an LLM with a thesis in community taxation law. My Lord handed an LLM in 1991 and awarded by Ahmadu Bello University, Zaria, and a PhD with a thesis in consumer protection laws, 1998, awarded by Ahmadu Bello University, Zaria. My Lord is the author of numerous journal articles in especially areas of consumer law, law of taxation, labor law, law of taxation, labor law. And my Lord is the author of the books National Industrial Court Jurisdiction, How Narrow is Narrow, Consumer Protection in Nigerian Law, Theory and Policy, and a joint author of the text, Elements of Commercial Law. I can go on, and I said I wanted to admit this. Apologies, I was not quite good at doing this before now, because I see that I still have several paragraphs to run into. So, my Lord, Permit me to, at this point, just officially thank my Lord and introduce my Lord. My Lord, a very good afternoon, and thank you for joining us, sir.
Thank you, SN, and to
Thank you
all
so much.
participants, good afternoon.
Well, thank you so much, my Lord. My Lord, what we set out to have is to have robust discussions around salient topics, salient areas in employment and labor law, with a special focus on what practitioners, and I mean largely lawyers who are paid before the court, should know about the evolving, I'm tempted to say the involved, even though it keeps evolving, jurisprudence in today's world of work, and has regularly churned out as from the decisions that come out, that are regularly handed down by the court. My Lord, without more ado, I'd like to ask a question. I would like to start with what, in my Lord's thoughts, would be the basic principles. I mean, we like to start from the elementary of the evolving jurisprudence that a practitioner before the NICN today needs to be abreast and aware of. I see in the room we have, as of now, we have 500 participants, and it keeps growing. So I reckon that I speak the minds of a large number who regularly come before the court. 520 persons, practitioners are listening in. And the first question is, what are the basic principles that we need to know?
Thank you, Falabi SN. Am I audible enough?
Yes, my Lord. Loud and clear, I can hear.
Okay, thank you very much. I'm not too sure the question itself will be very helpful, because once you're a lawyer, there's the assumption that we understand the basic principles of employment law, which is a shootout of the basic law of contract, only that it's a specialized kind of law of contract. Specialized in the sense that unlike what obtains in contracts, you walk into a market, you want to buy a pair of shoes, you want to buy a tie, you want to buy a shirt. What you enter into in exchange for money and the tie, the shoes, the shirt is a normal contract. But normal because what you're getting are goods and you pay for. But when you come to employment law, what you have moving away from you to an employer is your service. Now, do we take the viewpoint that because you walk into a market and bought a shirt and paid money for, when you offer your services to an employer, you are equally selling your service for a price? Now, a lot, and this is where the distinction between what used to be under the common law and what is being championed today is. Under the common law, it was very easy to look at labor, to look at service as some kind of commodity. Don't forget, some of these principles transcended from the period of slavery, where human beings were bought and sold. Now, the moment slavery stopped, and we were now contracting for the service of human beings, don't forget, at that time, the mental element was still that it was the human being that was like the subject of the transaction itself. Now, when we begin to look at modern day contract of employment law, particularly when you juxtapose it with what comes from the ILO, then you begin to see that some of these viewpoints are really not the critical issue. Human beings don't sell service. They merely make their service available. That they collect what is called wages is not in itself what makes the human being a commodified entity. So you begin to hear things in terms of principles, in terms of goals, like labor is not a commodity. Yet, the contract that exists between the employee and the employer is a contract of service. Of course, for other kinds of labor, a plumber coming to do plumbing work, we say the contract is one for labor. Yet in all of this, we are reminded that that contract cannot and should not be viewed as if it is the normal buying and selling of commodities. Now, if we don't understand this basic difference, we are going to have difficulty even appreciating the little basic rules that apply in a normal contractual employment relationship. And that is why I always remember the adage that, how is it put? Everybody knows the law, but the lawyer knows the exception. Now, when you come to court and you begin to talk in a sense that brings out the commercial nature of transactions in what involves human beings, the tendency is to miss the point. Now, in a contract of employment, for instance, even older cases will tell you that a court should not allow a contract which imposes servile conditions on an employee to go through. In other words, despite what contract law will tell you to be freedom of contract, yet the employment contract, because it is a special kind of contract, is regulated by more than just the terms and conditions that the parties themselves entered into. So when you talk about what should a lawyer know about the basic principles of employment law, it's more important to talk about what should a lawyer know about the goals or objectives of this kind of contract that is regulated by labor law. And the whole thing is, if you remember, I started off by saying the relationship of human beings, particularly when it comes to work, started from the era of slavery, where it was the human being himself that was being sold to go and work. The human being himself was a commodity. Now, in the kind of contract of employment we are talking about today, we have to distance ourselves from that kind of notion. And that is why you would find an entity like the International Labour Organization coming with what is called the Decent Work Agenda, promotes what is called dignity at work. Now, I like to always tell people at fora, employers have this adage: we employed workers, but what we got were human beings. The whole idea is to emphasize the fact that because you're giving your service for a price called wages does not make you any less human. And that's why even within the structure of that relationship, we are beginning to hear things like work-life balance. Now, COVID made us, which is what we're enjoying now with this webinar. I could sit in my office in Abuja and be talking to over 500 people. Everybody is keyed into it. That's the effect of technology that has done to us. But even this, in terms of the world of work, has its own implications. If I were to be doing the 8 to 4 o'clock kind of work, this webinar is 3 to 5. It means I have gone beyond 4 o'clock and I'm still working. It's possible I get home and certain calls, work-related, are following me. So, despite the fact that I am not a commodity to be bought and sold, despite the fact that I have dignity, Yet, I have little time because of work to do other things that my family, for instance, expects. So how do you strike that work-life balance? These are some of the issues when you begin to look at the goals of labor law that you must begin to address. But more fundamentally, and I like to say, we also assume that this labor law we're talking about is a labor law that is merely governing a relationship within the structure of an existing employment relationship. Yet, modern day labor law insists that there is more to just the employment relationship. In other words, this labor law, which seeks to regulate an employment relationship, even starts prior to the existence of that employment relationship. And that is why applicants, for instance, have rights. If you go within the structure of employment, ILO conventions, for instance, the Private Employment Agencies Convention, for instance, it makes copious provisions as to how employment agencies are to do the business of recruiting workers for employers. And within the structure of that convention, the ILO defines a worker to include an applicant. And Nigeria has ratified that, which means the rights that inure in virtue of labor law that we are supposed to be studying today also inures even at the point that there is yet to be in existence an employment relationship. And because the employment relationship can come to an end, the law also transcends situations where you are now out of work. And that's why we can talk about pension rights. We can talk about severance pays and the likes. And I think this is the convenient place to even mention a thing. Lade Dese and Folabi just wrote a commentary on La Casera. Now, the whole structure about La Casera is the existence or otherwise of a restrictive covenant as to somebody who left work. How many years does he have to stay by not working for an industry that resembles the one he was working? La Casera said 5 years. Folabi Kuti has written criticizing it, a critique that I agree with. But the point I want to make is this, that we can talk about that fact of covenants in restraint of trade, even when you are no longer in employment, tells you that the employment relationship goes beyond the existence of an employment relationship. So, the three levels at which, when you talk about labor law, employment law, is prior to entering into the employment relationship, during the pendency of the employment relationship, and when the employment relationship comes to an end. There are respective rights within the structure of labor law that you ought to know, which means that prior to an employment, an applicant, for instance, can have rights. During an employment, the employee himself in an employment relationship also can have rights. And at the end of an employment, again, rights inure in terms of the employer and in terms of the employee, as typified, for instance, by the use of restrictive covenants. An employer wants to be very certain that because of his business interests, I shouldn't allow somebody who had access to my trade secrets to go and work for a competitor. But you must balance that. Don't forget, I said we employed workers, but what we got were human beings. Here is somebody who has left work. You are saying for 5 years now, he is not going to work for a competitor. Which work is he going to do to earn a living? These are all concerns of labor law, which lawyers must know, not just the basic principles, but the overall structure, Because it is when you understand the overall structure that you can begin to understand how applicable the rights and obligations and privileges that inure from it can be operative. Now, we are today saddled with matters that have even questioned some of the things I am saying. It's enough to say there's an employment relationship for which you are an employee and the person taking you is an employer. But modern work systems, particularly if we look at what the definition of an employment relationship was in the old days, the tendency is that we carry that into modern day. And what am I saying? An employment relationship conjures up a relationship between an employer and an employee. And very often, the employee is seen to be a human being. And he is a human being and an employee because the employer exerts a measured control over him in terms of what he does, how he's going to do it, and so on. So we make that almost like an article of faith in determining who this employee is. But I'll give you a simple example. Take, for instance, trade union law. If you look at the definition of a trade union under the Trade Unions Act, it defines it by reference to workers on the one side and employers on the other. Now, we have the Nigerian Union of Road Transport Workers, right? And all of us know them. But if I ask you who is the employer of the road transport worker, almost invariably you are not going to find any, because majority of them who are in that union own their own vehicles. So they are not answerable to anybody. Yet, the basic structure of trade union law applies to them. And despite the fact that the Trade Unions Act defines trade unionism as a relationship between employees on the one side making claims against an employer on the other side. So the point I'm trying to make is, even when we understand some of these basic concepts, they are not watertight. They are not watertight concepts that are not, they are flexible enough to cover situations. So when you look at modern day systems, platform working arrangements, and so on, you tend to ask yourself, who then is an employer? Who then is an employee? And once you can't even answer these questions, you then begin to ask, is there even an employment relationship? If you look at very complex construction contracts, for instance, it's a common phenomenon today that you can have different levels of subcontracting. I give you a job to do something, you subcontract it to another person, that person subcontracts it. It goes on sometimes at levels that go up to 20 or more, to the extent that even the original person who gave the contract does not know ultimately who is going to do the job. Now, in all of these scenarios, who are you going to hold as an employer? These are the problems that modern day company law, labor law must confront itself with and find answers. So I go back to the question. It's not as easy as saying these are the basic principles. No, there are more fundamental issues. And I give a simple example. Look at the factors of production. We were taught factors of production in economics used to be land, capital, labor. Then later on, entrepreneur was added. Now, we have what is called a knowledge economy today. And because we have a knowledge economy, this thing we call labor is no longer being seen as labor. It is now called human capital. And because it is called human capital, the tendency now is that we are equating it equally with the capital that is originally within the purview of employers. So, can we see now a gradual redefinition of even the goals of labor law to bring labor not just as a contending force to capital, but as part of capital itself? But in all of this, you would find commentators, the ILO tells you, at the end of the day, the basic thing remains. So long as you're dealing with human beings, you must understand that they come with a dignity that is expected of a human being. And that dignity, whether it is in the workplace, howsoever it is called, must be respected. And if you don't respect it, then you are going to have problems, because if you tend to look at this human being as other than the human being that is he is, with dignity, with rights, you tend to forget even the basic structure of the labor law that we are all implementing. So, going back to your question, SN, the question is not as easy as basic principles. I prefer to look at them more as contending issues in terms of the goals that the labor law seeks to serve, because it's when you look at it in terms of those goals that you begin to appreciate why the rules are the way they are. Take, for instance, you get a judgment that says there is an absolute right to resign. It's a fallout of the days of slavery. As a slave, you could not even buy your freedom. So if what was substituted for slavery is the contract of employment, and you have a clause that says you can't leave, how different is it from servitude? So you would see conventions like the Forced Labor Convention, where ILO would tell you that the moment you hinder an employee from leaving, that has automatically become forced labor from that point. So when you have a decision or a case, a dispute, and you come to NIC, for instance, and NIC says, no, 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 no. Take, for instance, I have seen clauses in conditions of service where it is indicated that once you are facing disciplinary action, you can't resign. And ILO says, no. That restrictions to resignation is equivalent to forced labor, servitude, if you want to call it. You may also interpret restrictive covenants in that light. The man works for you and he's leaving. You say, no, because you didn't live how I want you to live. For the next 5 years, you can't work for somebody in the same kind of industry that you worked with. What is more than servitude, if not that? When even out of work, an employer seeks to control how you live your life. So these are contending issues for which it's the goals, the very reasons for which labor law came about that we need to concern ourselves with, which will then help us understand what we understand as basic principles. They are in themselves not basic because they are fundamental enough to dictate how certain decisions will go based on whatever is before a court of law or whatever the dispute is between the contending forces of an employee on the one side and an employer. I don't know whether I conveyed any. Hello? I can't hear you.
Oh, sorry, my lord. My lord, yes. My lord, I was saying that I thank the court, and on this, I think I speak the minds of many persons there. I thank my lord, I thank my lord for the rich breadth of thoughts shared on what was supposed to be a question as to the basic principles, but which my lord tried to redefine as more of interrogating the contending issues, the goals of labor law in itself. And as I listen to my lord, carefully highlights quite a number of issues on that. And I'll be returning to some of the things that I was jotting away. I scribbled quite a number of things away. I start with identifying the rights that an employee has, which my lord has carefully delineated into three spheres. There is first the pre-employment right, there's employment right, there is post-employment right. And my Lord had gone on to also condescend on specifics around some of these issues. The question I would like to ask, my Lord, in all of this, so we need to draw a balance. In all of this, how is the employer protected? Or what are the rights of that employer? I hear pre-employment rights. Clearly that inures to the employee or the applicants before he becomes an employee. But from the corpus of what my Lord has described, that employee is gradually being subsumed. Sorry, an applicant is also almost being subsumed into the employment relationship. In all of this, how is the employer, I mean, that entrepreneur who has brought the capital to enable the labor and run a business venture or concern, ensure that it's sustained and it remains in business, or generally, how is it protected even against the contending forces that seem to protect more? I'm not saying it does. It seems to protect more the employee in this. I'd like my Lord to address that. I'm told that we have close to 1,000 persons online who have joined us. We have over 500 on the Zoom platform and another 400 who have joined on YouTube. And the broad spread of professionals actually extend beyond lawyers. There are HR professionals also in the room, and they are also waiting to hear quite a number of these and want to share my thoughts on this, my Lord. So, my Lord, I'll take it back to my Lord now.
Now, you see, if I were still teaching labor law, I can summarize labor law as the tussle between job or employment security and flexibility. The contest between job security, employment security, and what is now called enterprise sustainability. Now, the employer always argues that if the business that yields to the job is not there, there will be no jobs. Just like the employees also say, if we are not there to do the jobs, the business itself will not be there. So how do you balance this? Of course, in balancing, the law has acknowledged that both sides have rights and obligations. An employee wants, and sometimes it is the balancing that creates the friction that we get when we talk about industrial action, strikes, go-slows, picketing, you name them. It's in trying to make this balance that we get this friction, and then, of course, those of us who are arbiters or dispute resolvers are then approached to be able to resolve the contending disputes and so on. But take a simple thing. An employee gets employed. He signs a contract, right? Now, there are two levels of the right to work that makes meaning to him. First, as an applicant, it is the right to get the job. Two, when he gets the job, he has that right to be given a schedule of work to do. We have seen cases in NIC where an employer, for whatever reason, simply transferred an employee to a desk that has no work schedule. And the argument in court has always been, but we are paying him salary. And the court said, no, because you're dealing with some, you see, work is not just for the money. Work is also what you call I have difficulty in using words here. Work goes beyond the salary. It has something to do with your dignity. It has something to do with your social life. You wake up in the morning and you have nowhere to go. Even your life expectancy will drop. But you wake up in the morning and look forward to going to work. Gives meaning and purpose to your very life. So it's not so much about the money that you collect as salary. Of course, it is part of it and it is an important part. So when you get to an office, to your workplace, and you discover that you are not given work to do, there is a problem. Because you didn't leave your house to go and sit for 8 hours doing nothing. So for your life to have meaning, you need that work. So when an employer gives you an employment letter, but refuses to give you work, something about your right to work has been infringed. But in doing that, an employer cannot be saddled with a recalcitrant worker. So where the worker becomes a problem, that is not doing the work well, because it's one of the grounds that ILO acknowledges you can dismiss, what they call dismissal for just cause. And usually just cause is something that is inherent to the job itself. And employer wants to reorganize. It used to be a labor-intensive thing. The employer wants to go digital, wants to go technology. In doing that, 1 or 2 job losses must be made. The employer has a right to organize. Don't forget, even at the point in which the employee is coming in, the terms and conditions for which he is coming in were designed by the employer. He could only do that because he has a right to do it. The only condition is that, okay, the law allows you to design the terms and conditions of the relationship. Go ahead and do it. But remember, in the event of ambiguity, it will be resolved against you. These are all attempts by the law to do the balancing process. While you have a right to design the conditions of service, in fact, there are cases that say you can change the conditions of service. In some instances where you have unions, for instance, the law requires consultation. So you have a right as an employer to do all of this. And under the common law, it used to be that you have a right to hire and fire at will for good cause or no cause at all. But today you find these things are beginning to change. I like to give the example, I think it was in 2012 or thereabout. ILO conducted a research amongst countries, although they restricted it to European countries. Countries where the rule was that you cannot dismiss without giving a reason, and countries where you could dismiss without giving a reason. They discovered that in terms of economic progress, the countries that had a rule that you can only dismiss with reason were doing better. Because in saying that you can only dismiss when you give a reason, you've reassured the employee, giving him a measured security in the job. And because he has peace of mind, he tends to be more productive. And the productivity of an employee is usually the profit that the employer gets. Because it is the employee's productivity that makes the business progress, that makes the business to do more and make more money. So the ILO discovered that countries where you have to give a reason before you can dismiss we are doing economically much better than countries that we are not. I remembered vividly when we were doing the declaration project, and the issue came up about Convention 158, the right on termination, where the rule is that you can only terminate for just cause. There was heated argument amongst the committee. I was a member of the committee then. I remember vividly the employer group said because an employee could leave unhindered, the rule must be made. If the employer must give reason before he can sack, then the employee must give reason before he can leave, which reason must be accepted by the employer. But this line of thinking is contrary to ILO jurisprudence on the issue. ILO is very specific that the employee must have a right to leave at any time he wants. The only conditions that may be imposed are reasonable conditions. For instance, you must give 1 month's notice. If you are not giving 1 month's notice, you must pay in lieu. But that you cannot even leave. And I have seen terrible instances before. I like to tell the story I heard in a particular conference when I was in Lagos. This young lady was employed by a bank. She was given a loan to buy dress and dress well and put in the marketing section of the bank to go and look for deposits. Now, as security for the loan she collected, she was asked to drop her certificates. Now, she was given, because she was in marketing, she was given targets. And because she could not meet the targets, she lost the job. And because she lost the job, she could not repay the loan she took, which loan was more for her to dress well, to go and look for money. Now she has been asked to go. She has not repaid the loan and her certificates have not been given to her. So she cannot even look for another job. Tell me, what is more servile than that? In the first instance, she didn't apply for the loan. It was the bank that gave it to her. Secondly, the bank was very specific what she should use the loan for. And thirdly, because she could not meet the targets, it was the bank that terminated and yet held on to her certificates, and she cannot even look for another job to be able to get money to repay the loan for which she had been given. These are the scenarios that labor law has to deal with. And because these scenarios are sometimes, they impugn the dignity of the human being himself. So you begin to find principles in labor law like unfair labor practices. And the whole idea is that, look, remember, like I said, we are coming from a history of slavery and slave trade. And don't forget, even today, ILO calls it modern forms of slavery. They still exist. You only need to go to most of our homes and you see how we treat domestic staff. And you would know that, yeah, modern day slavery is still a big issue. Not to talk about where people are now trafficked for prostitution, people are trafficked for whatever reason. You are lured into leaving your country. The first thing they do is to seize your passport. And then whatever work you are doing, there's a percentage you must give. When you want to leave, they don't want you to leave because your passport is with them, so you can't even leave. These are the realities we live with today, and these are the realities that labor law must contend with.
Well, thank you very much for the insight. insight shared on that. As my Lord spoke, my Lord made reference to that immutable right to resign by the employee, and anything to the contrary, ILO, and even our own local law regime from the Constitution and case law citation now says it's forced labor. The question is this, my Lord. Within that context, and then still looking at how the employer is protected or interest is also taken care of. Within that context, let's imagine an hypothetical situation that happens all too often, where the employee has given a notice of resignation to take effect in the future. My Lord, the blurry line, which I would like my Lord to share some light on this, it would appear that the general position or the blanket statement on that is that it takes effect almost immediately. Whereas in reality, many times, what you have is the employee gives an indication that if the notice period is meant to be 1 month, it gives a notice at the beginning of the month, for example, that at the end of the month, I would like to leave to another employment or to some other firm. The question is, within that window period, can the employer still exercise a right to discipline the employee where the need calls for it?
The answer is yes. In fact, there's a Supreme Court decision that was very specific. I think it had to do with a policeman. I can't remember the name of heart. It had to do with a policeman who gave 3 months' notice.
Yes, my Lord.
Of his intending retirement. And within the period of the 3 months, he did something that was wrong. And
Sorry, my Lord, I think my Lord is off. Hello, my Lord.
And before the 1 month elapses, you do something that warrants your dismissal, an employer has the right to dismiss you.
And so that's clear. That's clear. It happens all too often. And I will not revisit it, even though it would appear that there are divergent opinions, even from the courts in relation to that, a man who has resigned, the court cannot, the employer cannot.
No, not resign, not resign. The question was, he gave notice to resign.
He gave a notice.
Notice to resign.
Resignation
is immediate. You can resign immediately, subject to whatever the terms say in terms of paying in lieu. So you can resign, and don't forget there's even constitutional backing for it for constitutional office holders. Read section 306 of the Constitution. It's very specific. Any constitutional office holder under the Constitution, once he tenders his letter of resignation to the competent authority that has authority to accept that, the resignation takes effect immediately upon the receipt of that. That's section 306 of the Constitution.
Thank you so much, my Lord. Thank you so much, my Lord. Before I return to the other questions, I would like to go to the chat room and take 1 or 2 questions. Since we've invited that questions, participants and those who are joining us online can also drop comments and questions, and we would bring them up. My Lord, I have one here where the question is seeking an advice on how to go about the enforcement of outsourcing contracts. Enforcement of outsourcing contracts in the light of an unclear legislative regime and also the principles of probity. Enforcement of outsourcing contract. But I don't know whether this would come in. Yes, sir. Okay.
The point is, we don't have legislation covering outsourcing. I'm not aware of, but I'm aware that I think the Federal Ministry of Labor, laid down some regulations to cover outsourcing. Not outsourcing in all respects, but particularly from the point of view of recruitment and so on. Which takes me to a very fundamental issue. Each time I talk at fora and I said, we all need to go back to school, my point has always been guided by the jurisdiction that the third alteration gave to the court for the application of international labor standards and then conventions, protocols, treaties ratified by Nigeria that touch on labor. Now, a lot of people are yet to understand the magnitude of this in terms of our labor jurisprudence. In what would some say obiter, Justice Ogumiju at the Supreme Court advised that it's foolhardy for an employer today to think he can act without reference to international labor standards, acknowledging that the jurisprudence has changed. Now, if a case in outsourcing comes and we don't have local legislation on it, we can only fall back on international standards and practices in relation to it. How are you going to fall back on that if the lawyer who is canvassing a case does not even understand or know it? And that's why I keep saying the time has come for everybody to go back to school. Now, several countries have approached outsourcing differently. Another example I like to give is Section 20 of the Labor Act on redundancy. Beyond saying consult with the unions, Section 20 does not say what happens even if you don't consult with the unions. So, if you want to build your case on redundancy, and the terms and conditions in the conditions of service are not sufficient to give you the kind of recompense you want, the third alteration says you can fall back on international labor standards or conventions ratified by Nigeria. So you go and do the research and see, are there ILO conventions covering that? If not, are there standards suggested by ILO? And how do other countries treat the issue? Once you get answers to this, these are the things you plead. Of course, the opposing party is going to now also get his own research to debunk what you are doing. And then at the end of the day, the court will now balance the arguments for and against, and then now take a stance. That stance is what will now become the threshold basis for also looking at a similar thing previously. I'll give you a simple example. When I was in Lagos, I did some cases on work references. You leave the job. Your conditions of service say nothing about work reference. You write to your former employer, oh, I am getting a new job. Can you give me a work reference? He does not even answer you. So you come to court, and the court now looks at it. Where is the conditions of service? The court looks at it. There is no provision authorizing or obliging an employer to give you a work reference. Yet, you can't get the new job without this work reference. So we looked at some of the decisions, particularly in the UK, on the issue of work reference, and we're able to evolve basic principles around work references where we held that there's a right to a work reference. So when you talk about rights of an employee, for instance, this is not something categorically stated in any labor law, statute in Nigeria. It is not something, maybe, of course, in the public service rules dealing with the public sector, there's a provision for it. But most private employers don't have it. So we had to now state that for an employee who is leaving an employment, again, it comes down to the issue of rights after work. You have a right to work reference. And what do the cases say? The right to a work reference is the right to a work reference that is truthful. Not a work reference that that's, I can't remember the language the courts use in this instance, but there are instances where an employer had to be damnified, and huge damages awarded against an employee because he made a work reference that was injurious to the employee. And in this area, the issue then became, is liability in contract law or in tort? And the court said it can be either. So it's for you as counsel to then choose which one will give you more compensation in terms of what you are looking for.
Yes, my Lord.
But now, the point I want to make is, it's because of references to standards outside Nigeria that we could now develop a right to work reference in Nigeria.
My Lord, I am still in the context of the work of the court and the goals of the labor law. There's a question that someone has posed, and he reads that why does the NICN mandates an employer in the oil industry to seek ministerial consent to release a Nigerian employee when that same minister was uninvolved in the employment at the onset? In other words, why is the industrial court giving vent to the release the subsidiary legislation made by the minister further to the petroleum industry? It's a question that's been asked. My Lord, what I've noticed is that with each question, my Lord actually covers quite a lot. So what I intend to do is, because there are quite a number of questions there, I'm not even looking at areas that I thought that I would like to interrogate, or those questions flowing from, further thoughts, inquiries flowing from the responses my Lord has been given. I'm trying as much as possible to cover many of these questions here. So I would like my Lord to take that alongside these other questions that's been asked, that on the position of the law concerning employees' confirmation, whether it must be written or delivered before it can take effect. I reckon that is an employee who is under probation, whether there must be a formal confirmation.
You may need to repeat the first question.
Okay, so the first question is basically asking that, I think interrogating the judicial work in giving vent, or the reasoning in giving vent to the release signed by the minister, the petroleum minister, further to the petroleum.
Now,
that there must be ministerial consent before anyone working in the oil and gas industry can be
if
terminated.
you start with the Supreme Court decision in Shell versus Chukuma.
Yes, madam.
Shell versus Chukuma was, I think, the first case where the issue of ministerial directive as to the sack of Nigerians in the oil industry came up. But what excuse, a point a lot of people missed out is that that ministerial decision in Chukuma was a circular.
Yes.
Was a circular. And the Supreme Court acknowledged that that issue was not an issue on appeal before them. But they still offered an opinion, which of course technically would rank as obiter, to say that that particular thing at that time could not affect the right of an employer to hire and fire and will, and not to have forced on him a willing employee that he is not willing to take.
Yes.
Now, after Chukuma was decided, the ministerial instruction now came by way of secondary legislation. go to the Interpretation Act, it defines legislation as both substantive and delegated. And so long as you are within the confines of the delegated authority, secondary legislation is as valid as the substantive. Now, after Chukwuma and secondary legislation was done, part of the problem was that the authority to do the delegated was given to only the Minister of Petroleum. But some of this delegated legislation were done by the Department of Petroleum Resources. So when the matters got to court, the court said, no, you can't, because you don't have the power. The minister to whom this power was delegated had no power to delegate another person to do. Now, come to the Petroleum Industry Act 2021. You would see totally new provisions there. One, the minister has powers to make those rules. In as much as the successors to DPR, the upstream commission and the downstream, they are also empowered to make the same rules. So the question of a minister not having power to delegate does not arise, because in this particular instance, if you go to the Petroleum Industry Act, you would even find a provision that authorizes the minister to delegate. Now, that was the basis upon which I had to decide the case of Shell. I think in 2021, the facts are relatively, it was a case that was argued primarily by Shell because the defendants came late and they did not give sufficient reasons to be allowed to put in their defense. So I foreclosed them. So it was a case where the decision was given basically upon the arguments of Shell. But something happened, which I pointed out in the judgment, and I think counsel to Shell didn't allude his mind to. The issue Shell brought to court was whether one of their staff was sacked or disengaged, let me use that word, because that wasn't even the issue before the court, was disengaged. And then she went to DPR to complain. DPR queried Shell. Shell answered. DPR said, we don't like your answer, and issued a second one. Shell answered. DPR said, no, you have not sufficiently satisfied us. So, two things: reinstate the woman and pay a fine of $250,000. So Shell came to court challenging the directive to reinstate the woman and challenging the imposition of fine on them. Again, part of the argument of Shell, particularly regarding the directive, was that the directive was done by DPR, not by the minister, and that because the minister didn't have power to delegate, that instruction was wrong. But there was something that was missed out. The day DPR wrote to Shell was 16th of August, 2021. And that was the day the Petroleum Industry Act came into force. And we all know that when a cause is being determined by a court of law, the law applicable as at the time the cause of action arose is what applies. So, as at 16 October, when DPR said, reinstate this woman and pay $250,000, what was the law applicable? Was it the old Petroleum Act or the new one? I held that it was the new one because that was the day it came into force. Now, in holding that it is the new one, which had provisions saying whatever was done under the old act is to be deemed to be done under the new act, I had to interpret that the directive, the secondary legislation, even though was done by DPR, is deemed to have been done under the act that's under the new act, where the minister himself had powers to delegate. So the question of delegated authority was not an issue, because under the Petroleum Industry Act of 2021, the minister was empowered to delegate. So I held the secondary legislation to be valid with references to the Interpretation Act and so on. Then as to the validity of the penalty, again, there were cases cited. I looked into them, looked at the provisions of the Interpretation Act, and concluded that by the Interpretation Act and some of the case law authorities that were cited to me, I was able to show that, look, the minister under the Interpretation Act and the Petroleum Industry Act had powers to impose the penalty. So I held that. The issue whether you could impose a servant. Now, the issue was this. I referred to a decision Supreme Court decided by Karibi White, where he held that where the common law is contrary to legislation, common law must give way. Now, the question was the rule that says you can't force a servant on a master. Is it a common law rule or not? And I answered that it was a common law rule. Now, the instrument that says you must consult the minister before you sack, is it legislation or not? I answered it is legislation. So I held that this common law rule cannot withstand this legislation. And accordingly, I ruled that the legislation superseded.
My Lord, I'm sorry to interject there. I take it back what my Lord just said. The rule that says you cannot impose a willing employee on an unwilling employer.
Yes.
It's common law.
It's
Master
a common
servant.
law rule.
Yes, common law. I agree. In relating sin, I mean, I was just trying to see the analogy that is involved in relating it to the scenario of a minister directing. I'll need my Lord to look at it from the context that is the minister the employer?
No, but we are having a situation where legislation provides for a step to be done.
Mm-hmm.
So the issue now was, as between this common law rule
by the master
legislation, which should I take?
Yes, sir.
Should I go with you cannot impose, which is a common law rule, or should I go to a legislation that says you must consult before you can sack? Which, if you don't do, it means your action falls foul of that law and accordingly is null and void. And if it is null and void, it means the woman was not even sacked at all. She remains a staff.
My Lord, I think my Lord has answered. Except my Lord wants to share that thought. I'll quickly go to another question, my Lord.
The second one, I'm not sure I got it.
Yeah, this one in relation to confirmation. An employee who has been under probation, and it's expressly indicated in the letter of employment, the provisional employment, that confirmation is in 3 months, and if he's not confirmed, he's not an employee.
2 years. Usually probation is 2 years. Majority, if it's 2 years. the point is, I'm sure you remember the contract rule which allows contract by conduct. And then the rule that says if you enter into a contract for a specific term, which allows you to renegotiate the contract after the expiration of the term, if no negotiations take place, but you continue in the contract, the law assumes that you are continuing under the same terms and conditions as the original contract that expired. Now, if you are on probation and the conditions of service say after 2 years you are to be confirmed, if you are not confirmed, you should be given a letter terminating you. At the end of 2 years, you are not given a letter terminating, you continue work and you are being paid salary. In fact, it is not even NIC. I think there are many Court of Appeal decisions on this issue where the Court of Appeal said there is now a deemed confirmation. And because there's a deemed confirmation, you no longer can exercise your right to terminate at the end of probation for non-confirmation. So if you really want to terminate, you must do it at the point the probation ends. If you allow the man to continue to work and you pay him a salary, then the courts will deem the confirmation itself, whether or not you issued a specific letter of confirmation.
My Lord, in what way would the court interpret a service of employment NDA, non-disclosure agreement, that extends indefinitely after an employment contract has ended, whereby the clause will have the tendency of affecting future prospects with regards to knowledge gained from the previous rule?
Has it anything to do
not
with
to disclose any information? My Lord, I'll take it to be a species.
For me, the basic rule is that contracts in restraint of trade are unenforceable. Public policy deems it to be illegal, though it does not use the word illegal, because if it is illegal, it means you can't even sustain it. So the law simply says it's unenforceable. But the leeway granted is that the man who wants to enforce that particular clause must show reasonability. You must show that it is reasonable, and reasonability is determined by reference to the time, to the geographical area you are restricted, and other factors that are taken account of. And that was why some of us were surprised with La Casera just decided, which accepted 5 years as a reasonable period for the operation of a contract of restraint of trade, without even telling us how 5 years is reasonable, how and why. Because if you read most of the literature, most of the cases on this subject, not just in Nigeria, even outside Nigeria, I have never seen anywhere in the world where a restrictive covenant set to apply for 5 years was accepted as reasonable. La Casera will be the first, to the best of my knowledge, that is making that kind of holding. But like in your critique, you pointed out, La Casera, the cause of action arose long before the Federal Competition and Consumer Protection Act came up. And if you look at the act in section 68, it provides a base period of 2 years, not more than 2 years. In other words, for contracts in restraint of trade to be deemed to be reasonable, it must not be more than 2 years. So what this means is that if tomorrow La Casera is cited before me, all I have to do is refer to section 68 of the Federal Consumer Competition and Consumer Protection Act and say, look, La Casera cannot withstand this. it is understandable that the cause of action in Lacasera arose before the Federal Competition and Consumer Protection Act came into being. But because it is now applicable, of course, courts are enjoined to take judicial notice of laws that are applicable. So a court of law will be duty-bound to take account of Section 68 and be able to apply. So with the benefit of the Federal Consumer Competition and Consumer Protection Act, one can say categorically now that reasonability in terms of years is any period, but not more than 2 years.
Well, there's a question. Thank you so much.
Which means it is possible depending on the area, like I did in relation to training bond. When I was in Lagos, I did a case involving overland. And the training bond was to go for simulation for 6 months. And then the training bond restricted the pilot from leaving for 3 years. And I said, no, you can't go for a training of 6 months and be tied down for 3 years. That's not reasonable. So, because simulation is to allow you to fly for 6 months. It means after 6 months, if you don't go for another simulation, you can't even fly. I remember vividly even writing in the judgment that I was even doing Overland a favor, because if the pilot didn't go on simulation for the next 3 years, he's entitled to be paid his salary, even if it doesn't work.
The balancing act. That's a balancing act. Thank you so much, my lord, for that. I'll quickly move to the work of the court. My lord, there's a concern. A question has actually been posed in relation to getting a clarification on costs, gauging the approach of the court on the award of costs as full indemnity basis. Specifically, a concern has been raised that an action filed at the industrial court because of the increased rates of matters filed in busy dockets like Lagos could very easily long gestate between a year, 2, 3 years. And at the end of the day, upon a successful outcome, the litigant is awarded less than 200,000, and sometimes 500,000, max regularly, max 500,000 as cost for the whole action. And knowing fully well that many a times the lawyers even had more than that for coming to court, for disbursement, filing of papers and all of that. So the concern is, what is the court's approach, or what is the court really doing in view of the express letters in Order 55 of the Civil Procedural Rules, the court, on what the court should take into account many a times? That it would appear that the cost is actually being tuned down and is not really is not being awarded on full indemnity basis anymore or at all.
Actually, you must also understand where labor disputes are coming from. Here you're dealing with a party that may even have difficulty paying his way to come to court each time a case is adjourned for. Secondly, what we are doing is symptomatic of what also obtains with other courts. Only in exceptional cases, and they come far between, do you hear news about huge costs being awarded. And very often it's because you would notice some kind of anger on the part of the court for bringing a case you should not have brought, for raising issues that have been resolved yet you are bringing, and things like that. Just this year, Justice Abang of the Court of Appeal, I think, imposed 3 million naira costs personally on a senior advocate. because the senior advocate came and was looking for leave to appeal against a decision which came from NIC to Court of Appeal to the Supreme Court. And Justice Aban was like, look, you should know that appeals in respect of matters like this end here. So for you to file for leave to go to Supreme Court, you are just trying to add to the to the cases in our docket and waste our time. So then there's another case where Justice Abiru came down heavily on the senior advocate in the Supreme Court, saying that the matter should not have gone beyond the High Court, given the kind of issues that were raised, issues that have already been resolved by the Supreme Court. So it is in cases, exceptional cases like that, do you find huge cost being awarded in millions. And very often it is against the counsel who took up the cases themselves. And again, that's not without us understanding why. Anytime matters like that get to Court of Appeal, Supreme Court, very often you would see somebody who has applied for SAN is looking for cases. So you are going to have those kind of things. And what was I used to say, what's the definition of abuse of court process? Anything other than for the cause of justice is an abuse of court process. So if you are filing an appeal, filing a suit because you are looking for cases to apply for sanction, that's an abuse of court process. It has nothing to do with the cause of justice. And in some cases, you would see the litigant himself is nonchalant. He's just not enthusiastic. And yet, the matter is being pushed on every little score used. So, the point I'm trying to make is the award of less than huge sums as costs is not peculiar to NIC alone, is general to other costs. But ours is even worse when you look at the kind of litigants we have. I know there are instances of abuse, but those are exceptions. I remembered I did a case where the claimant, an employee, came. I was in Lagos then and was asking for 90,000 naira. And I remembered asking the counsel, is it because of 90,000 naira you are coming to court? And the words of the counsel were, we are not doing it for the money, we are doing it for principle. And I said, principle? He said, yes. Okay. So the matter went to trial. The claimant went into the box and gave evidence. During cross-examination, documents were shown to him indicating that he was the one that left without giving notice. So in truth, when he was arguing before me that he was terminated without notice, the evidence revealed that he left without giving notice. And the notice period was 2 weeks. So I looked at what he was entitled to in terms of if he were to be given 2 weeks notice, the pay in lieu of 2 weeks notice. I calculated, I think it came to, is it 40,000 or 50? I can't remember. So I now said, because he's the one who should give notice, I think it was 40,000. Since he's the one who should give notice, he is to pay the employer 40,000 naira for leaving without paying in lieu of notice. And then I awarded cost of 50,000 naira to make up the 90,000 that brought him to court in the first place, and ordered for him to now pay. So instead of him coming to get 90,000 naira, I directed that he pays now 90,000 naira to the employer. I don't know whether he paid, because of course, you know, once you make an order, until you don't go back to files and checking whether it's been followed or not as a judge. So as I'm talking to you, I don't know whether he paid or not. But the point is that his lawyer said they are coming for principle, when in actual fact, they were the ones who were the wrongdoers. and I couldn't allow it to just go, despite the fact that I know he's not in a position to pay any heavy thing. So since he came looking for 90,000 naira, I ordered that he pays the employer 90,000 naira.
My lord, from cost, and the question has been asked around it, I'll need to, we'll move to damages, not necessarily the compensatory damages in events of industrial accidents. So there's a specific question, for example, that where an employee was injured in the course of employment and the employer took care of the hospital bill, is the employer still entitled to any compensation? Well, that's specific. But broadly, I'm looking at it from the perspective of redress of workplace injuries under the thought of negligence or statute law, specifically the Employees Compensation Act, which in a number of decisions the court has said has its own range of steps to take when relief is being sought under that. But where relief is sought under the thoughts, exploring the vehicle of the thoughts of negligence, I wonder, my lord, is there a common or unanimous position, or what would appear to be a clear, discernible pattern from the court as to the quantum of damages that would be sufficient to
I can't hear you. Hello?
many of these workplace injuries. And in things are coming out, sir.
Can you hear me?
Hello, my lord. Hello, my lord.
I wasn't hearing you. You may need to repeat. Hello?
I can hear you loud and clear. Can you?
Okay. It's
okay.
Now I can hear you.
Can you hear me?
I can hear you now.
Okay, my lord. So I would also like the court, I would like my lord to help expatiate a bit on what would appear to be either the position of the court, the approach of the court, or
Hello? Hello?
Hello, my lord. Hello, my lord.
I can hear you now.
Sorry. I was up. Yes, so I was asking as to redress needs of a very pathetic story of what employees have had to go through in cases of industrial accident. And the employer tries to avoid liability. He ends up in court. And you read in the judgment, the judge giving a vivid narrative of the gory side of that injured employee who came to court to lead evidence. And at the end of the day, the quantum awarded is also arguably not one that can last, can provide for the immediate needs of such an employee who more than very often would have been relieved from work. I was thinking, I would like to know, what is the position, what's the approach of the court in relation to this? Redress of workplace injuries under the thought of negligence.
There are two options, actually. You can
Yes,
choose to go the path of negligence,
yes,
which by my reckoning is usually very difficult to prove. If you've done sufficient reading in the law of negligence, you would know that despite the famous neighbor principle by Lord Atkin, the application of that principle over time has been more to restrict liability than to enlarge the scope of liability. But that is a story for another day. But you have the choice to go under negligence and be saddled with the responsibility of proving duty of care, breach of duty, and resultant damage. Or you can take the route of the Employee Compensation Act. The problem here is that employers are expected to have registered and paid the yearly contribution for you to be entitled to claim under the Compensation Act. Now, if you choose to claim under negligence, it means you have waived the right to claim under the Act. I think it's Section 12 of the Employee Compensation Act, which makes that provision. If you choose to claim under the Employee Compensation Act, it means you have waived the right to go through the route of negligence. So you must choose one, either negligence or the ECA. Now, if you choose the ECA, it has its own internal provisions. The National Social Insurance Trust Fund will look into your claims. Whatever it does by way of assessment of what you are entitled to in terms of compensation, if you don't agree with the sum, there is an internal appeals body within the Social Insurance Trust Fund that the Act says you must appeal to. Now, if the outcome of that appeal is still not satisfactory to you, that is when you can come to NIC. You can't come to NIC before exhausting the procedures. But there is something which is actually not utilized by counsel. Where an employer refuses to register with the Nigerian Social Insurance Trust Fund, what it means is that if you are injured, you cannot go to them for compensation. The question arises, since you cannot go against them for compensation, and if you don't want to use the negligence route, can you, for instance, that's the normal negligence route, can you, for instance, sue the employer for statutory, what we call statutory negligence? These are options open. But again, if you go and read write-ups by particularly English writers on statutory negligence, it's not just something you walk into. There are parameters you must satisfy to be able to make claims under that. But in all of this, as a counsel, you need to weigh which of these will give me the highest compensation I can give to my client. I can't give you an answer because statutory negligence is not something that is in vogue in Nigeria. If you read most of the negligent cases, even when suits are filed for breach of statutory duty, it is often not claimed as statutory negligence. It is simply claimed either in terms of administrative law, where a particular government body refused to act, but not within the context of statutory negligence. So these are the options open. The normal negligence, where you prove duty of care and all that, or you go under the ECA, or where the employer, who is your own employer, refuses to register, and so you can't even approach the ECA, whether you can claim as statutory negligence. What I cannot tell you right now is whether an action in the normal negligence will preclude you from claiming for statutory negligence, or you can claim the two. I can't give you that answer because it has never been contested. And if I say I'm giving you an answer now, it's like I'll be prejudging. But these are all the issues, the questions that you lawyers need to think through and work on.
Thank you very much, my lord. Still on some of the questions that I have here. My lord, there's a question that hovers around minimum wage. It's phrased thus: the obligations of employers regarding minimum wage and its enforcement in Nigeria, with a special focus on employment in law offices. Except my lord wants me to go to another question, because I would imagine that minimum wage is complied with in law offices. Okay, well, my lord can take that alongside this question. Under what circumstance can be made liable in defamation at the expense
can you
of
take that again? I didn't hear you. I didn't hear you. Can you take that again?
The circumstance, under what circumstance can a former employer be liable in defamation at the suit of a former employee?
My only answer can be...
Can he be liable in defamation at the suit? Work reference.
Subject to the rules of defamation. There is the problem of even whether we have jurisdiction over defamation in the workplace. Some Court of Appeal cases say we have, some say we don't. So if that issue comes up, like I was telling one of the judges in Lagos High Court, I said, look at the most recent, because that's what we are told we should do. Look at the most recent decision and then you go by it. Right now, I can't tell you which one is the most recent, but I know there are decisions that say we have, there are some that say we don't have, but that's even not the issue. I, as a person, in some of my earlier decisions, held that because defamation is sui generis, in other words, it can found a cause of action in its own right, it was better for you to pursue a defamatory suit in the High Court. Of course, some Court of Appeal decisions looked into this our stance and overruled us, even though subsequently we had other Court of Appeal decisions saying no, that we don't have. And then another one said we do. So it's oscillating. But the more fundamental point was, at the point where the Court of Appeal overruled us and we started taking defamation cases in the workplace, there was something we noticed. Lawyers assume they could succeed in defamation through the back door by coming to NIC. In other words, in coming to NIC, they felt they were not bound by the normal rules of defamation in terms of a successful suit.
Yeah.
What were we taught in school? For you to succeed in defamation, you must prove that there is a defamatory statement, which is defamatory, that it refers to you, and it was published. Then if it is slander, you must prove actionable damage. But if it is in writing, damage is assumed or presumed. Now, For you to make a claim in defamation, even the rules of pleading tells you what to do. You must set out the defamatory statement. If it is in a language other than English, you must set out the translation. You must plead how it is understood by reasonable people and all that stuff, particularly where it involves innuendo and so on. But the lawyers who come to us would simply tell you, oh, this man has been terminated. And because of that, the employer issued one statement that nobody should deal with him. Accordingly, this thing is defamatory. Now, and this is where the danger was. Because you didn't meet the requirements of a successful action in defamation, it meant you did not prove your case in defamation. So all the claims you have in defamation, because you didn't prove them, would then be dismissed. And once they are dismissed, it means you can't relitigate them even in the High Court, assuming you choose or you want to do that. So our advice was that it is better for you, if you feel strongly about the defamation component of your case, to go to the High Court and go and litigate it, because it allows you to go through the hog there. But for us in NIC, defamation comes in two forms. I have just discussed defamation in the first form, where you are making a specific claim for defamation and claiming damages separately for defamation. That is the first manner it can come to us. The only thing is that what you claim to be defamation happened in the workplace. Yes. The second, and which is the more important one for me, and which I think is why lawyers make the errors they make. Defamation can be raised with us not for purposes of defamation, but for purposes of exemplary or aggravated damages. In other words, if you're complaining about how you were sacked or treated by an employer, the issues about there were publicities about what I did wrong for which I was sacked. The issues about, oh, the man wrote to certain employers to say they shouldn't take me, are all matters to be factored in if you succeed in determining the quantum of damages applicable to you. If you remember, there was a particular decision in Lagos when Justice Ogaku Court of Appeal was there, where, I can't remember the name of the case now, but it was segmented into two. The employer said, we terminated him and gave him, I think, whether it was not a query, that there was something they said they gave to him to justify the termination. But the records show that nothing of the sort was given. And Justice Ogaku held that that in itself grounded a second ground for damages, different from termination without following the due process. So, for purposes of quantum of damages, matters relevant to defamation may be applicable. If you read cases like Majo Kodumi and British Airways, that was part of the reasons why at the end of the day, the court awarded 2 years salary as damages.
Salary leave.
Because the court reasoned, if you say damages should be computed by reference to only the notice period, he said notice period is what he should have done in the first place. But he didn't. Now, you terminated him and gave the impression that he did a wrong. He committed an offense, like in the banking sector. After giving you a commendation, the following day they give you a letter saying your services are no longer needed. We've interpreted that within the context of the banking sector to say there has to be something amiss. So we will not take that kind of termination without you telling us why. You must give a reason. Because if you don't, there is more to it. One, for terminating, you must report to CBN. There is a file the CBN has open for those who work in the financial sector and are dismissed or terminated or relieved of their work, which means the gentleman or the woman or the lady can never get work in the financial sector again. So, for you to be able to get away with that, you must give a reason. And if the reason is such that is false, it affects the quantum of damages. Not because you proved defamation, but because what you did, being wrong, aggravated the fact of the termination. But what we see from day in, day out is that lawyers don't seem to even appreciate this. And of course, the few cases we've seen where they specifically pleaded alongside termination, defamation, we found out that they've not followed the strict rules of pleadings for a successful action in defamation. And of course, neither did they follow the rules in terms of proof for a successful action in defamation.
And I thank my Lord for the insights shared on the last question. But whilst at it, my Lord also made reference to this issue. It's a burning one in the employment law space, termination without notice. Flowing from what appears to be the orthodoxy of the immutable right, or what would appear to be the immutable right of the employer at common law to hire and fire. My Lord has identified in the financial sector, it's taken that the industrial court will not allow termination without notice. The question is it one that is now applied across board, all the sectors, before the industrial courts, bearing in mind that the specific convention that introduces this, the 1982-158, is not one that's ratified in Nigeria. Is it one that's, is that requirement, is true requirements at the industrial court? The termination must always be with notice.
In the main,
irrespective of the
most of my colleagues have held in several cases that you must now give reason. And they did it because they took convention.
Sorry, not notice here. With reason.
Sorry, with reason. They did it because they took Convention 158 as evidence of good practice. Not because Nigeria ratified, but it is evidence of good practice. But there's something I want to charge all lawyers. Apart from Convention 158 itself, there is a recommendation that follows Convention 158. Usually, ILO makes a convention, then the recommendation explains the kind of things to be factored in for purposes of giving effect to the convention. If you read the recommendation, I can't remember the number, the recommendation that goes with Convention 158, you will find that most of the items indicated there, which would amount to breach of Convention 158, are matters that can easily go for unfair labor practices. Just go and take a look at that recommendation and read it. Majority of the items there are, take for instance, termination without reason. It can conveniently be argued under unfair labor practice. Termination for other than job-related reasons. Termination for union activities. These are all matters that can conveniently be argued under unfair labor practice concept, which, of course, the Constitution gives jurisdiction to the court.
Yes.
So, these things, there are no hard and fast rules. When I give the example of the banking sector, it is because we deem the banking sector as a very sensitive sector. You don't expect what obtains in the banking industry to also be applicable maybe in the teaching sector or in academics. Considerations will differ. And there's no way you can lay down hard and fast rules for some of this. I like to take for instance, people who even complain about our Section 12 of NIC Act, where we are, I think it's either Zambia or Uganda. They have a similar provision which extends to criminal law. Ours is even just civil. They have a provision that allows their court to dispense with the Evidence Act in the interest of justice, not just in civil cases, but in criminal cases. There are certain things I always say which involves an employee in a relationship that it is very difficult not to have a rule like that. I tell people, you only need to bring out your ID card and look at the back. It will tell you this is the property of so person. It is not your property. The day they tell you your services are no longer needed, the first thing they are going to collect is that ID. Now, if you want to use the ID as a piece of evidence, do you think an employer is going to give you back that ID? And what is the rule as to production?
Yeah.
Even if you order production and he doesn't, the rule says use secondary evidence. It didn't say compel him.
Yeah.
Use secondary evidence. Now, let's assume you are a public sector person. The ID card, in quotes, is public document. Then you have a further requirement. Even if you have a photocopy of your ID card stuck somewhere in your files at home, you can't bring it until you go and certify it because it's a public document. Yet you know that if you go back to your employer, he will never certify it for you. So this is the point in which provisions like that come handy to assist, particularly if an employer or a defendant is not saying what you are bringing is fake, is not contesting the authenticity. He is only contesting that it is not certified.
Yes.
We think that in circumstances like that, Section 12 ought to save the day. And like I said, Nigeria is not even alone. You have African countries that have a similar provision that even extend to criminal. I'm happy that senior counsel like Femi Falana have seen the utility of Section 12 of the NIC Act. And I know in most public fora where he speaks now, he advocates that all courts should have a similar provision like Section 12 of the NIC Act. Because whether you like it or not, the technical rules of evidence have a way of ensuring that you may not get justice at the end of the day.
Yes, ma'am. My Lord, thank you very much. I'm mindful of that. My Lord, in one breath, I would lump two questions together. And I reckon my Lord will take some time in answering. One relates to the applicability of the Public Officers Protection Act, or basically the statute of limitation at the industrial courts. Very much aware that the court has always been guided by the oscillation at the appellate courts. One, someone has had, can a preliminary objection based on Section 2A of the Public Officer Protection Act, that is arguing that the action in itself should be determined in lemon without for being stale, being statute bad, can it be taken without calling evidence? Especially if a claimant alleges abuse of office and malice in a suspension or dismissal. That's one. Closely tied to that is what presently is the position of the law at the industrial courts. Considering that, yes, what is the position of the law in the industrial court and the applicability of the Public Officer Protection Act or Limitation Act statute generally to contracts of service
Can you hear
that's
me?
on one hand. So on the one hand is the Public Officers Protection Act, statute of limitation. There's also a question that's been asked and wanting to know the position of the law or the thinking of the courts on dispute resolution clauses in contracts of employment stipulating arbitration as a first cause means of dispute resolution. What is the thinking of the court as to clauses indicating that matters at first cause disputes should go to arbitration? When such clauses, and I can extend it, this has not been asked fully in the question, but I reckon this is what the person is seeking to know. In light of the decisions of the courts that if the way the particular clause is couched is further or expresses that it is further and or they would have in consideration the Arbitration and Conciliation Act, now the Arbitration and Mediation Act. What is the position of the courts and when ordinarily the subject matter is employment?
Let me start by explaining. You see, sometimes context is necessary. When we talk about labor is not a commodity, the first thing that should come to mind is that, let me do a little bit of digression here. When we were in school, commercial law was taught to us from the perspective of merchant people, businessmen. Whether it is banking law, whether it is sale of goods, the emphasis was what obtains, and you find that even in the maritime sector. When you talk about maritime law, rights in rem, they were not about seafarers who gave the labor. It was more about the vessel. That's why in maritime law, the vessel itself is a human, is an artificial person that can be sued and that can sue and be sued in the name of the vessel. Now, because the law was termed commercial law and was understood within the context of businessmen, it meant those who were not businessmen, but related with them within that structure, were never factored in by law. If you go to the Arbitration and Conciliation Act, I have not seen the new one. I have not read the new one. So don't quote me on the new one. Those who have read it will confirm to me or not. But at least the old one was very specific that it dealt with commercial matters. Now, if you go to the Trade Disputes Act,
the new one is also there.
If you go to the Trade Disputes Act, there's a provision there that says the Arbitration and Conciliation Act shall not apply to resolution of trade disputes. So it tells you that labor disputes is a special species of disputes which has its own arbitral procedures. Now, if you come to us with an employment contract, and the employment contract says, in the event of a dispute, you must submit to arbitration. Are you hearing me? If submitting to arbitration, if submitting to arbitration is under the Arbitration and Conciliation Act, you are not going to find assistance from us. Because in the first instance, you have entered into an agreement that is it unlawful, illegal? I don't know which word now to use. Because Arbitration and Conciliation Act is not supposed to regulate the arbitration of labor disputes in the first place. So if both of you agree that that is the law that will bind you, you cannot come to NIC looking for orders to make you do that. But The Constitution gives us power to interpret arbitral outcomes. So if without coming to us, you go and do your own thing and you come up with an arbitral agreement, you can come to us for interpretation because the Constitution says we can interpret. We are not going to ask you under what law you did the arbitration. So understand something from me. You cannot come to NIC and say, order that we go and do arbitration under the Arbitration and Conciliation Act. We will tell you that because that act does not apply to labor dispute, we cannot authorize you to do an illegality. But howsoever you do your arbitration, if you enter into an arbitral outcome, the Constitution says if that arbitral outcome is for the settlement of a trade dispute or a labor dispute, you can come to NIC for interpretation. That we will listen without asking you under what law you did it. It is the outcome we are now looking at. So, within the structure of the Constitution, that's why, for instance, we have supervisory jurisdiction over arbitral bodies that are resolving labor disputes. So whether it is private arbitration or the statutory arbitration under the Trade Disputes Act, an arbitral outcome can be interpreted. If you go to the Trade Disputes Act, you would find provisions that permit the Minister of Labor, for instance, asking us to interpret an arbitral award that has been confirmed. That we can do because the Act says so. And when we are doing it, we are not going to do it under the Arbitration and Conciliation Act because that one deals with commercial arrangements. And this is one area I have tried over time. And somehow, even in our curriculum in schools and so on, the point is not really understood. That's why till tomorrow, you will not find, if you open your law report, you won't find as subject index issues like consumer protection, for instance. When I was doing my PhD, I came across materials, and this is where my viewpoint changed, that when it comes to economic relationships, there are two sides of a coin. Economic relationships are hardly between parties of equal bargaining power, except in pure commercial instances. Take, for instance, a bank going to borrow from another bank. The assumption is that because they are banks, they are of equal bargaining power. So the rules that regulate that kind of transaction can never be the same in terms of outcome with where a bank is giving you a personal loan to go and buy, maybe build your private house or something. It can never be. In the same manner, within the structure of a maritime or within the sector, the maritime sector, a carriage of good contract by sea cannot give you the same outcome in terms of the contract between the owner of the vessel or the vessel itself with those who work the vessel. That dichotomy, the disparity, is what led ILO to come up with the Maritime Labor Convention of 2006, which now solely concerned with the rights and privileges of seafarers. Because if you leave it to the normal carriage contract, it will never factor their interests. So, what point am I trying to make? For economically disadvantaged groups, the law had never been in their favor. Something special needed to be done. And that's why in instances such as this, law assumes a paternalistic role. Labor law came about because workers cannot compete in terms of bargaining power with employers. So you needed labor law to give them rights and privileges that will bring them at par, at least, even if it is in principle, at par with employees. The same thing with producers and consumers, landlord and tenant, banker, bank customer, the aircraft carrier and air passenger. These are all relationships of one weaker economic group relative to a more powerful economic group. So, if this is the scenario for which the rules operate, it means you cannot but be careful how you transpose wholeheartedly rules meant for businessmen to also cover non-business people who have to transact with businessmen. I always like to give the example of Sale of Goods Act. If you read the Sale of Goods Act or the Sale of Goods Law of the states now, what's the measure of damages? The measure of damages is what you are going to get if you had made a profit out of it. As an individual, if you buy a car for personal use, you are not thinking of profit. You are not thinking of profit. When you buy a car for personal use and the car turns out bad, there are three things that come to your mind. Either your money is refunded, or the car is repaired, or it is replaced. What we call the R remedies, 3 R's: refund, replacement, or repair. Now, these 3 remedies you will never find in the Sale of Goods Act or law. Yet, as an individual, you are bound by the Sale of Goods Act or law, depending on whether it is at the federal or state level. Now, if you are bound as such, or even look at the rules as to implied terms in the Sale of Goods Act or law, implied term as to merchantability. Even hear the word merchantability from merchant. And the implied terms operate only when the seller operates in the course of a business. Which means if we do private sales, I have a car I want to dispose of and you want to buy the car, you come and we do, there is no implied terms applicable because one of us is not acting in the course of business. And because one of us is not acting in the course of business, it means the Sale of Goods Act in terms of the implied terms is inapplicable. Now, that is the kind of law that is supposed to give succor to a buyer who is an individual and not a business person. And in doing this,
my love,
I have...
Thank you very much, man. Okay.
Should I go on or... Hello?
Yes, my lord. I actually just wanted, my lord refers all the time. My lord, yes, my lord. Thank you very much, my lord. I just want to bring it a little bit within context, which my lord often refers to as well.
That context is also
the point is
applicable in
sufficiently
labor
made.
law. That's the point. That context applies in labor law.
My lord, I agree.
The
point is sufficiently
take the relationship
yeah,
of
the point is
employee and
sufficiently
employer.
Yes.
Or even maritime workers.
Then, my lord, in relation to that question. Yes.
Go ahead.
My lord, in relation to the question, does it matter and still with looking at the goals, still within the context of the goals of labor law, that contract, more often than not, the employee did not participate in the drafting of the clause that has now expressly indicated Arbitration and Mediation Act. In any event, the provision referred to in the Arbitration and Conciliation Act remains the same in the Mediation Act. Courts there still remains listed courts to the exclusion of industrial courts. It's still commercial undertaking and all of that. So the point is, or the question is, does it matter, or is it anything of context that the court will consider in perhaps stretching to accommodate when such an employee brings such an action? That's one. Two, or closely related to that is also the concern, and I know my law will weave it round to make it maybe clearer. The court, on the one hand, will not embrace any disputes or any application seeking, for example, maybe an application directing that the employer or the adversary should appoint an arbitrator when it is further to the Arbitration and Mediation Act. But the outcome of what comes out of that, the court can enforce, because the Constitution expressly states.
Constitutionally, we have jurisdiction to interpret arbitral awards in labor.
That power. Absolutely.
So we will do that. But if you come to us and say, yes, because we have a clause that says we should go to arbitration under the Arbitration and Conciliation Act, direct us to go and do that, we will tell you we can't do.
Yeah.
Because the act is not supposed to apply to labor disputes. So how can we order you to go and do arbitration in an act that should not apply to labor in the first place? But if the clause is simply fluid, there's a clause that says direct that we go for arbitration, and it stops there, of course we can give such an order.
Yes.
But the one we will reject is you telling us under the Arbitration and Conciliation Act, we should order you to go and do arbitration. That will tell you no, because that act is commercial, applies to commercial transactions, not labor.
Okay, my lord, time is fast, but we will return to this at some point. I'd like my lord to take the question on the public protection.
Okay, I even forgot that
the limitation.
So that's one of the major knotty headaches we have. And the oscillation of the cases have moved not just from Court of Appeal, but it has also involved the Supreme Court. I remember last year when Justice Areola was retiring as the Chief Justice of Nigeria. His autobiography, I had the honor of doing the review. And I seized the opportunity to draw attention at that time to two Supreme Court decisions decided on the same day in 2022. The same day, one said Public Officers Protection Act applies to employment contracts. The other said it did not. Both Supreme Court decisions decided on the same day. And I asked the question, based on follow the most recent rule principle, which between these two cases is the most recent? But somehow by, I think, February of this year, 2025, there's a Supreme Court decision, where the gentleman was suspended. And you know, by First Bank and Longe, Supreme Court said a suspended staff remains a staff. So despite that, the gentleman filed challenging the suspension, but he sued not within the 3 months of his suspension, but after. And Supreme Court held that Popper caught up with him. And accordingly, he has no case. Now, Even arguments as to suspension being a continuing injury. I think the lawyers wanted to be ingenious there. Even that argument that the suspension should be deemed a continuing injury was rejected by the Supreme Court. Now, I'm not unaware of my colleague, Justice Zaro Shogbe. He decided a case after Okoronkwo, and the arguments before him, he came to the conclusion that POPA was unconstitutional. So as it is, we have that decision in NIC from Justice Zaro Shogbe that POPA is unconstitutional. But of course, for something to be unconstitutional, I must confess I'm yet to read the decision. It's a case I'm handling where I have asked parties to address me on the application of the Okoronkwo's decision. So when parties file, that will be the opportunity I will have to read Zaro Shogbe's decision to be able to now say how he came to the conclusion that POPA is unconstitutional and how it relates to Okoronkwo. So these are the issues we have on ground in terms of the oscillation which results from what we are getting from our appellate courts. The truth of the matter is that, and this is where the problem arises, most of the decisions, even at the appellate level, are decisions that did not refer to previous cases on the subject for you to come to the conclusion that they have been specifically overruled or not. But as the Supreme Court said, in the event of conflict, follow the most recent. Hello?
Yeah, my lord, we can hear you.
Okay. So I just made the point that, as the Supreme Court said, in the event of conflict, follow the most recent.
Hello.
Hello?
Yeah, thank you, my lord. I think we've lost the connection from Mr. Falabi Kutiesen. Okay, he's joined. He's back on. Back on, Leonard.
Thank you very much, Victor. Thank you very much. Well, I actually saw that you had come on, so I know you were waiting for us to bring this to an end. So I was on briefly, and so I don't know. We can still ask my lord the very last question. There are quite a number of questions. Unfortunately, we overshot the time. It was meant to be for 2 hours, 3 to 5, and the comments have just depicted what has been happening in the last 2 hours, 15 minutes thereabout. No, sorry, 20 minutes thereabout. It's been educative, enlightening, and on all levels, very enriching. And then we can go on and on and on and on. My lord, the questions are many. I will just leave my lord with last thoughts in relation to the broad overview. I was coming to labor relations. There's a question I wanted to ask on freedom of association, especially which happens to be the big elephant in the room in light of contemporary issues. How this can be managed to always ensure harmonious industrial relations, and to what extent, if any, the amplitude can be exercised by the employee on the one hand, and then what restrictions can the employer, if any, can put in place. If my lord would just want to bear last thoughts on that, I would apologize that we would not be able to take the many questions, the other questions that are inbox. But I trust, I have no doubt that the organizers will find a way around how this is dealt with. I trust the Practical Legal Academy for that. So, my lord, I'll leave it to take the last question, and then I'll bring Tobina back. Yes, please go ahead.
All I can say regarding freedom of association, given the plethora of cases that are pending, is that there's a huge literature by ILO on Convention 87 and 98. Both combined relate to freedom of association. But let me make a preliminary point. Freedom of association is governed by Section 40 of the Constitution. If you look at Section 40 of the Constitution, it deals with the right to form or join a political party of your choice, trade union, and association. I've had calls in previous write-ups and fora to advise counsel that it's foolhardy to be citing a political party case simply because it was decided under Section 40 of the 1999 Constitution in a trade union case. Just like it is foolhardy to cite a case relating to Part C of CAMA, an association registered under Part C of CAMA, and you are citing it to support a claim in trade unions. The truth of the matter is that a trade union is not a political party. Neither is a trade union an association registered under CAMA. In fact, if you go to the Trade Unions Act, you will find provision very specific that says Companies and Allied Matters Act does not apply to trade unions. So, if the Supreme Court gives a decision in respect of a political party or an association registered under CAMA, and you come to NIC and you are citing it in terms of freedom of association in support of a trade union or against a trade union, it's foolhardy. That's the first general point to make. The second point to make, like I said, there's a huge literature on Conventions 87 and 98 by ILO. Lawyers will do themselves a lot of good if they familiarize themselves with that literature, particularly if you are litigating on issues relating to trade unions. Because our mandate to apply these conventions ratified by Nigeria means we are also bound by the literature expounded by the ILO. Lastly, before now or up to this point, the ILO had always treated the right to strike as a subset, part of Convention 87 and 98, particularly Convention 87. But if you read Convention 87, you are not going to see the right to strike mentioned by name. So the employer group have always queried that logic. And the claims by employer group has always been that Convention 87 does not cover the right to strike. So over the years, this tussle was there year in, year out, until I think last year, the governing body of ILO decided, because based on ILO constitution, where there are legal issues as to interpretation of the constitution or any of the convention, the final arbiter is the International Court of Justice. So ILO has made a reference to the International Court of Justice for an advisory opinion as to whether the right to strike is covered under Convention 87. Now, we are waiting, I think some few months ago, the International Court of Justice took argument. So we are waiting for the advisory opinion. The effect for us is going to be this. If the International Court of Justice comes out now and says Convention 87 does not cover right to strike, it means we have to fall back on our local legislation regarding right to strike. We no longer can use Convention 87 as the yardstick for determining rights and obligations as to even freedom of association for purposes of Convention 87 and 98. But if the International Court of Justice comes out with an opinion that says it is covered, then it means there is now confirmation that all the literature on Convention 87 as espoused by ILO up to date will remain as it is and is now the governing norm. So we will now be reinforced in terms of applying Convention 87 to also take account of this literature. So as we await the outcome of the advisory opinion, again, lawyers may need to follow the developments and see how it ends up.
My Lord, I've been asked with the kind permission of my Lord to have this to close at 6. I know that we've really stretched, my Lord. The questions are still coming in, and I've been asked to just lump about 4, and that will take to 6 and we close. My Lord, with the kind leave of the courts, we can proceed, my Lord.
Okay.
Thank you so much, my Lord. There's a question. Section 11 of the Labour Act allows parties to agree. Does Section 11 of the Labour Act allow parties to agree on the notice period different from the timelines prescribed under Section 11 of the Act? So there's a notice period indicated in Section 11 of the Labour Act that for anyone that has worked, should be 1 month. So the question is,
as public servants, for instance, if you go to the public service rules, you are going to find notice period. Take, for instance, pre-retirement notice is 3 months. Even as judges, you are expected to give 3 months notice. So very often, in as much as, and don't forget, which is again another thing lawyers sometimes don't factor in. Most of the provisions of the Labour Act relate to workers. And workers is defined by reference to junior staff.
my Lord, my Lord, I agree. But I would just say it's still interrogating that. I know my Lord has hinted that Section 91, which is the definition section of the Act
defines
itself,
workers restrictively. It defines workers restrictively. So
yes, but
those provisions
those
provisions where workers, the word worker or workers is used. Of course, you have to go back to the restrictive definition of, but those provisions that are fluid.
Yeah.
I always interpret the Labour Act as a Labour Standards Act, giving you the minimum standards below which you can't go.
Oh.
Now, if it gives you the minimum standards below which you cannot go, is there anything fundamentally wrong 3 months? Particularly where it is not worker that is involved. Can you, I don't know whether you have the provisions of Section 11 of the Labour Act there. Let's be certain how it is actually couched.
Okay, my Lord, I'll just, I'll pull it up. But whilst at that, I also know that the way the Supreme Court has interpreted a similar provision in the past is that parties can actually contract out of a contract, out of a legislation. The only time parties may not be able to contract out of a legislation is if there is a penal provision stipulated to compliance in that
you also remember
provision.
the Supreme Court literature about permissiveness and directory.
Yes.
Which is the point you are making.
Yes.
If there is no penalty,
parties,
then
no penalty,
even when it tells you shall do this, that it is merely the directory.
Yes.
Not an obligation.
Yes. So, my Lord, so okay, that's now 91. I just want to read the express Section 11. So, Section 11. Either party to a contract of employment, 11.1, either party to a contract of employment may terminate the contract on the expiration of notice given by him to the other party of his intention to do so. 2, the notice to be given for the purposes of Section 1, subsection 1 of this section shall be 1 day where the contract has continued for a period of 3 months, 1 week where it has continued for 3 months, less than 2 years, 2 weeks where more for a period of 2 years, less than 5 years, 1 month where it has continued for 5 years and more. So that is section 11.
So it tells you that there
ranges,
is no...
it ranges. No, the maximum in section 11 is actually level 2D. That's 1 month. But and I think the concern here is that of late there's been an attempt by the Labor Department or Labor Ministry to enforce that parties cannot contract out of the statute. That the statute says it should not be more than 1 month.
Well, all I know is the ministry does not interpret statutes. The ministry does not interpret statutes.
They try to enforce.
Interpretation is a function of the courts.
Courts as a companies.
The interpretation is a function of the courts, not the executive.
Yeah. So that is really the thinking that can parties, because traditionally that is who it's always been. In respect of whether AMA applies to NIC, will my lord's answer still be the same if a party brings an application under the inherent jurisdiction of the court to go arbitration?
What is AMA?
AMA is arbitration and with the apology, I was using the acronym. I thought, my lord, just like ACA anyway. Arbitration and Mediation Acts. Will my lord answer still be the same if the application is under the inherent jurisdiction of the court, not under AMA, to go arbitration for in line with the agreement of parties?
No, of course, if you ask the court to direct arbitration without more, that's perfectly okay. It's when you restrict it to under the arbitration, is it now Arbitration and Mediation Act, then the issue whether the court should direct you to go and do what should not apply comes in. And I know I did a case where I held that because the Arbitration and Conciliation Act is not factored for labor disputes, the court cannot be asked to direct an arbitration under that act.
My lord, that was a question that came out in Raveli's case. And I think it was really Raveli's case that opened this door. But I go back to the question that was asked, my lord. I seem to take a slightly different view. Still, whether the answer of my lord would have been the same. And this is the reason. So the question is, the clause, and I reckon this is what the person who has posed the question is saying. The clause in the employment contract is very specific. In the event of dispute, so I just drop an hypothetical one. In the event of dispute, parties will go to arbitration, one, then as it is usually couched, the more often than not that is usually couched, the arbitrator, it should be with 1-man arbitrator or 3-man arbitrator, further to the provision of the Arbitration and Mediation Act. So that is expressly stated in that clause. So there is a dispute. An application has been filed to court because the adversary, whether the employer or the employee, after being served a notice of arbitration, has refused to appoint his arbitrator. So the application is brought to court and smartly couched to be under the inherent jurisdiction of this court. That further to clause 13 of employment agreements made so, the court should direct parties to go to arbitration. Can the court grant that? In light of the question answer my lord has given, I think that's
the one I did was very specific. Yes. They wanted an order.
Yes.
They came, in fact, it was boldly written as a heading of the process under the Arbitration and Conciliation Act. It was boldly written. And they were very specific. Now, the first thing is you came to us under the Arbitration and Conciliation Act. And the first question was, is this act applicable in this court for you to come under? It's like filing an action under Fundamental Rights Enforcement Procedural Rules in NIC.
Yes.
NIC is not a high court under Section 46 of the Constitution. So if you file an action under Fundamental Rights Enforcement Procedural, it's dead on arrival. You can file a complaint the normal complaint. You can file an originating summons and plead whatever provision of the fundamental rights that you say is breached. But you cannot file it under fundamental rights enforcement procedural rules, because those rules were made pursuant to Section 46 of the Constitution. And Section 46 says it is applicable to only High Court, which is defined as state or federal. But that's it. So the same logic, if you come to us that you are coming under this act, you are coming under an act that does not apply to us. But if you hide it and you say you are coming under the inherent jurisdiction of the court, of course, our own act allows us supervisory jurisdiction over arbitral bodies. Don't forget that the I think Section 254C3 or so, apart from Section 7.3 of the NIC Act. So if you come under those provisions,
yes,
if you come under those provisions, we will listen to you. But if you are coming under Arbitration and Conciliation Act, which does not apply to us, we will not.
Yeah. My Lord, does it matter? So
it matters
because
it matters. You see,
the reason I say that is this: the same Supreme Court has said that there's nothing like inherent jurisdiction if it's not tied to the substantive jurisdiction of the court.
That's what I'm saying. We have provisions that allow us supervisory jurisdiction over arbitral bodies. Why can't you come under that provision?
But when my Lord will be considering the application before the court, my Lord would be referred to the particular clause of the employment contract that says that parties should go to arbitration, right? And in that clause, even though it's not been listed
now, when the court is going to make an order, the order will not be go and do arbitration under the act that does not apply to you. The order will be go and do it under maybe ILO process or whatever, the ones that apply to the court.
Yes.
After all, is it not the rule that if you file a motion and do not state the law under which you come, so long as the law exists, the motion is not invalid?
Yes.
Is it not the rule?
Yes, my Lord. And some clarification I would have liked my Lord to also make is that in relation to which, of course, I know is the position of the court on coming by further to the fundamental enforcement rules. If my Lord could still share that sort of that, considering that the fundamental enforcement procedure rules in itself is a set of rules made in the hand of the Chief Justice.
The Chief Justice is not without his restrictions as to his powers.
Yes.
Wait.
Yes, sir.
Section 46 of the Constitution tells the Chief Justice to make the rules.
Yes, sir.
Can person who is delegated do something beyond the enabling powers? Section 46 deals with enforcement of fundamental rights in high courts.
Yes, brother.
And tells the Chief Justice of Nigeria, for purposes of this section, go and do the rules. Then the Chief Justice of Nigeria does the rule and says it applies to NIC. NIC is not a high court. The point is, I have written fairly lengthy on this issue. The point is that even when the fundamental enforcement procedural rules allow or disturb the local standing rule and allow somebody who is not a victim to file for a victim, I still believe that that is contrary to Section 46. Because if you read Section 46 of the 1999 Constitution, you will see, I think I have it close here. Just give me some few minutes. 46.
My Lord, what my Lord is looking for is what I can offer is that, if my Lord recalls, enforcement of fundamental rights, long before Abacha and Fawenyi got to Supreme Court and Pachacholono GSC had an opportunity of looking at this issue, enforcement of fundamental rights used to be bogged down with all manners of objection. There must be an ex parte. There's a point I'm trying to make. There's a point I'm trying to make. That is the philosophy that seems to be behind all of this. So in Apache and Fawaimi, Apache Chalonu says 46 is a provision of the Constitution that seeks to protect rights of individuals, liberty, freedom, and all of that. And to that extent, the interpretation at every point in time should be liberal. It was even after that provision that courts were now allowed to start.
Let me read
yes,
the heading. The heading says Special Jurisdiction of High Court and Legal Aid. That's the heading of Section 46. Yes, Special Jurisdiction of High Court. Yes. It now goes 1. Any person who alleges,
yes, my Lord,
that any of the provisions of this chapter is being or likely to be contravened in any state in relation to him.
Yes, my Lord.
Now, when your brother comes and files a suit on your behalf, is it in relation to him?
My Lord,
any person who alleges that there is this breach in relation to him now may apply to a high court in that state. It didn't say to the state high court. It didn't say to the federal high court. It said to a high court. Now, I made the point that if you look through the whole, it's the Supreme Court that said interpret Constitution holistically.
Yes, my Lord.
Now, if you look at all the provisions of the Constitution, anywhere federal high court is intended, it uses the word federal high court.
High court, yes.
Anywhere state high court is intended, it uses the word state high court.
Yes,
but where it is either of the two, it uses a high court. And that's what it used here. Then you go to 2, subject to the provisions of this Constitution, a high court shall have original jurisdiction to hear and determine any application made to it in pursuance of the provisions of this section, and may make such orders, issue such writs, and give such directions as it may consider appropriate for the purpose of enforcing or securing the enforcement within that state of any right to which the person who makes the application may be entitled under this chapter. Then 3, the Chief Justice of Nigeria may make rules with respect to the practice and procedure of a high court for the purposes of this section. How can you make a provision outside this section? By giving things that this section did not contemplate. It talks about any person who complains that there's an infraction in relation to him. Then you make a rule and say, for purposes of local standing, even one civil society can file an application. That's certainly reading into this Constitution what is not there. If Supreme Court is telling us that by that fact, they have permitted the Chief Justice of Nigeria to extend this provision, you know, there's a general, I don't know whether you've heard it, but there's a general criticism of decisions relating to the Constitution, where courts now have been accused of reading into the Constitution things that are not there. It didn't start today. As far as I'm concerned, portions of the Fundamental Right Enforcement Procedural Rules are outside of this. That's my opinion. And then, of course, when you now say you want this to apply to NIC, I say NIC is not contemplated. That does not, you see, people make the mistake about what I call process and remedy. The fact that you cannot bring an action under Section 46 does not mean you don't have a remedy. Yes. People make that error. You can file your normal writ. When Bello versus AG of Oyo was filed, the gentleman who was convicted for murder, and before his appeal could be heard, they went and shot him. And the family, they sued by way of a writ. It will take time, but you will get your remedy. But no, lawyers want shortcut. So they will come under Fundamental Rights Enforcement Procedural Rules in NIC. And I tell them, no, you may have a valid case, but go and file a complaint. You can't even file under Fundamental Rights Enforcement Rule and then be saying, convert it, because you don't even have a competent suit for purposes of conversion.
My lord, point well taken. I mean, the only thing I would just had to close that and move to another thought is two things, my lord. In my view, to my mind, to give a purposive interpretation to the Constitution when it is a matter dealing with enforcement of right, it must be a liberal interpretation. And again, I repeat, that was a decision, that was a view taken by Patacholo, the JSC, in Abacha and Fawe.
For purposes
if
of
we're
remedy.
to follow that, yes, for
purposes of remedy.
My lord,
not
it was
for
after
the process.
That. No, my lord, it was even after that it didn't matter if enforcement of right was commenced by writ or by any other form. I can return to
the
it
difference
later.
is this. The difference is this.
Because the court was that should not be the issue.
SN, go and check.
Yes, my lord.
All actions that were commenced under fundamental rights enforcement procedure rules. Please check how much was awarded as damages. Then compare it with those ones that were commenced by way of writ and tell me whether the amount of damages given is the same.
The same.
Cross-check whether the amount of damages awarded in cases filed under fundamental enforcement rules is the same with damages awarded in complaints or in writs of summons. Hello?
My lord, we thank you. My name is Agaba Idu. I am a member of the board of the NBA Continuing Education Council. And this has been very extensive. It's been very, very, very deep, my lord. So we thank you very much for what you have done. The MBA Institute of Continuing Education is very happy to have been involved with you in this matter. And we thank you profusely, my lord. It has been very, very educative and insightful. We would like to continue having you on board some other time and some other events that we will put together. Thank you very much, my lord.
You are welcome.
My lord, thank you so much for joining us. And we have no doubt that we can always call over and we'll take it further from there. The questions are many, and just like I've indicated, the organizers will definitely have a way of having this attended to in the next 3 days that this session continues. Thank you very much, my lord, and thank you to everyone.
You're welcome.
Yes.
And good night to everyone.
Night, everyone.
All right.
Yes.
Holy Lionel Silk, thanks a lot.
Thank you so much. Thank you so much. Yeah. Right.
Victor. Victor, over to you.
He's muted.
Victor, please close the session.
He is muted.
Just a second. Idris, can you close this? Victor is not there, please.
Just to thank my lord, my name is Idris Mohammed. I'm the Chief Operating Officer of the Practical Training Academy. On behalf of the Practical Training Academy, we'd like to thank you most sincerely, my lord. As the Learned Silk actually said, this has been totally engaging, very, very educating, and extremely enlightening. You'd see by the response we have got on both Zoom and on the YouTube platforms, the responses have been enough. And as you can even see all the thumbs ups, the claps, and the love emojis that are coming up on this Zoom. So just to tell you, my Lord, that we are extremely grateful. We have gained a lot, tremendously. Myself, it has been extremely beneficial to me. I've learned a great bit. And to say a huge thank you to you. We asked you to come for 2 hours. You have stayed almost 3 hours now, and we are very grateful. But like Oduvatrice, we might still come back to you again, my Lord. I hope you not get tired of us, but it is all in the bid to continue to have education sent out to all lawyers in Nigeria. That is the focus and the mandate that the Practical Training Academy has. So on behalf of the board and the management of the Practical Training Academy, we say a big thank you to my Lord, Honorable Justice B.B. Kanyib, for spending this much time with us and for lifting and giving us great education today. We are most grateful to you, my Lord. Thank you very much.
You're welcome.
Okay. Thank you. So tomorrow, the employment law series continues, and the links for the next session that will be coming up tomorrow will be shared across board, across all the platforms. We encourage and we thank, we must not forget to thank Mr. Afolabi Kuti, Senior Advocate of Nigeria, for moderating today's session. We also thank the over 1,600 people that at one time or the other joined in this training session. It will continue tomorrow, and all the relevant links will be shared across all our platforms. So thank you to everyone that has joined us today. And this particular mention to the chairman of the Practical Training Academy, Mr. Tobena Erojikwe, who has put all of these together. A huge thank you to everyone. Thank you, and we look forward to seeing everyone tomorrow. Thank you once again, my Lord. And we will close this session for today, and by His grace, tomorrow we'll continue. Thank you to everybody.
Thank you, my Lord. Thank you so much.
You're welcome.
Thank you, learned colleagues.